the gentleman. For what purpose does the gentleman from Georgia, the sponsor of this legislation, seek recognition?
Move to strike the last word.
With that, gentleman is recognized.
Thank you, Mr. Chairman, for holding this important markup. My bill would restore fairness to the American justice system by reasserting individuals' rights to access the court system and to a jury trial. The FAIR Act would ensure that men and women contracting with more powerful entities aren't forced into private arbitration where the bigger party often has the advantage of choosing the arbitrator in an unappealable decision. Arbitration clauses have permeated American life in recent decades. They've seeped into our cell phone contracts, our medical paperwork, our employee handbooks. Their opaque language, written by well-paid corporate lawyers, is often not understood by people who aren't trained attorneys. These clauses are hidden in updated terms and conditions, incorporated into mid-year employee reviews, and implicit in purchase contracts, and they all prevent us from having our day in court. Pre-dispute forced arbitration is a private process that subverts the purpose of the Seventh Amendment by preventing contracting parties from using the American court system when a dispute arises. It was created as an option for contracting business-to-business relations. Unfortunately, the United States Supreme Court has allowed big business to impose forced arbitration clauses on consumers and others of unequal bargaining position in take-it-or-leave-it circumstances. In these cases where the more powerful contracting party can choose the judge, the jury, and the law applied, consumers and employees are put at a distinct disadvantage. There's no requirement in an arbitration proceeding that testimony be under oath and under penalty of perjury, and even worse, the private nature of the proceedings means that it does not create a public record and is not appealable. Repeated anti-consumer activity by companies never sees the light of day, and individuals remain incapable of holding more powerful entities accountable. This needs to change. When a loyal employee who happens to be a reservist or a National Guards person gets deployed and thereafter fired for getting deployed, they can't take their former employer to court, and something is wrong with that. When a sexually harassed employee is forced into a private proceeding where her harasser gets to pick the judge, something is wrong with the American system, and the entire process is private. And when American consumers need a legal education to understand what they're signing, something is wrong with our judicial system. The deck has been stacked against everyday Americans in favor of big business for far too long, and the pressure on the meek and powerless has only become greater as powerful corporate interests have realized that they can avoid accountability by incorporating arbitration clauses into every interaction they have with consumers. The FAIR Act would make the system work for everyone the way that our Constitution intended. Finally, I'd like to take this moment to recognize the victims of forced arbitration who are in the audience today, men and women who've been deprived of their rights because of arbitration clauses. Thank you for being here and for your bravery in telling your stories. It has resulted in us getting to this point where we are marking up this bill, and it has 222 co-sponsors as of today. I'm very proud of that, and we're here to ensure that what happened to you cannot happen to other people in similar situations, and thus we're restoring justice